Hey everybody, happy Friday. Hope you all had a last awesome week of February as we get ready to finish out February and see what March is going to bring. Hopefully more warm weather and not another extended winter like the groundhog told us. My name is Zeno Lancaster with Lancaster Law Firm, here to talk to you today about how do you make, I first said all this, those of you that paid attention to the posts this past week. Hey, B, good to see you. I first posed this, when can you relist the property? If you're under contract, when are you able to go then relist it? And I got, first of all, I posted this on my personal Facebook, posted it on in this group, got all sorts of answers. So one thing I found out very early on, hey Michelle, thanks for watching, and Stephen. One thing I found out very early on is that realtors don't agree on this, or at least there's no consensus, which that's why we have this kind of group, right? So that we can all get on a consensus, help each other, and make sure we're being compliant, and of course following the rules, keeping each other from stepping on any landmines and that sort of thing. So that's why I'm wanting to get this out there, because realtors are not on the same page about it, and I've seen it cause some problems in the past week or two. So here to share, here to learn from you guys. Maybe I have it wrong on certain issues, so please comment below if you guys have something that I'm missing. Always do that, by the way, because it's a wisdom sharing group. I'm not the old wise man in this group. I'm here to learn just as much as you guys are. So hoping we can all learn from this. So when can you, and not relist the property, although you all knew what I meant by relist the property. Oh, Zeno, it's always listed on the MLS. You just changed the status. Yes, I'm sorry. You're right. So I'm not in the MLS world, right? So I didn't realize, I think everyone, where did I get the word relist from? Y'all. I got it from y'all. So some people out there are using the word relist to relist property when they mark it active instead on the listing that's still there, okay? And that's what we're talking about. Hey, Stephanie. Hey, Tom. So what I'm really saying is when you have an MLS listing and it's under contract, when can you go mark it active again? Because the contract's not working out, right? So that you can take more offers. And I'm not talking about backup offers. I'm talking about when can you take and accept a new buyer's offer on that active MLS listing. Okay, I think I've set the foundation for this discussion, right? So I'm a listing agent. I have a contract. I have an offer that we've accepted, and I want to be able to mark it active again, walk away from this offer, try to find a new buyer. That's where we are. When can I do that? What do I need to have? I posted this question up. I got various answers. Here are some of the answers I got. Nothing. I got, it's always listed. So I think both of those answers were, instead of, they either didn't know what I meant, and that's fine. I should have worded it better. I'm learning that listings stay active, and you don't relist it. You just change the status, right, to active instead of something else. So thank you for helping me learn that, guys. I'll try to do it gracefully. So nothing is not what I'm talking about. And if that was really the answer to my actual question, it would be wrong. So I've also got a bunch of answers that said we just need a termination signed by the buyer and we're good to go. Also, it depends, right? So it depends what document you're using, but that's not always the right answer, okay? We had some various other answers. What you need for a fully terminated contract so that you can mark that listing active again is a valid termination of contract signed. Otherwise, that contract remains open, even if someone is actively breaching it. Okay? So if your buyer just doesn't bring money to closing, the contract just doesn't poof, void, terminate. It is voidable by the seller. The seller can void it if they want to, but they don't have to. It could stay open subject to the buyer's breach, and vice versa. Seller decides they're not going to sign a deed for closing. Buyer doesn't have to sign a termination. They may leave it open subject to the seller's breach and not sign anything. So if that happens, number one, it's active. I'm sorry, I shouldn't use that word. The contract is still in place. You cannot mark the listing active again. And my understanding, you guys correct me if I'm wrong, is when you're saying, hey, send us offers, we can accept them, and you would be the first person in line to buy it, that means it's active on the MLS, active. If it's under contract or whatever other term it uses, you can't, because it's under contract. You can take backups, that sort of thing. So to make it active after you've accepted that contract, you need a few things. Now, you have to have a signed termination. What kind of termination? Can it just be signed by the buyer? I got tons of answers. Well, during the due diligence period, the buyer can sign a unilateral termination. Correct. Absolutely. Okay. So that's one instance where you can do that. The second page, signed by the seller, that just deals with earnest money release. Correct. No problem. That's correct. So the seller would only be able to dispute that. And I will say it depends, right? I will say with exception, because what if the buyer signs a unilateral termination of contract a day after due diligence ends? What if they sign that and they say, okay, it's terminated? Now the seller can then go, well, okay, I'm not signing this and it's not terminated, because they don't want to give back the earnest money. They're not going to go mark it active again, but they can't dispute all of that and then go mark it active again. So you have to be careful with that. The buyer actually needs to have signed that unilateral termination during due diligence period for that to work, okay? You can't just wait 3 days after it ends and then send the unilateral and be like, oh, well, they can relist it. That's not how it works, okay? So what do you need after that due diligence period passes? No one brought this up, okay? So at least not in the 2 posts that I made. So there is that mutual termination of contract. So it's titled Mutual Termination of Contract. So what does that tell you about who has to sign it? What does that tell you about, is it just the buyer, just the seller? If it's mutual, it's both, right? So it's right there in the title, Mutual Termination of Contract. And if you read through the mutual termination of contract, which I've got brought up right here, every single paragraph in this thing says it's to be mutually agreed upon. The termination. They have to agree on the disbursement of earnest money in this document for it to be valid. If it says right here in note number 2 at the very top of the page, if this is someone trying to exercise unilateral right to terminate, you're using the wrong form. Don't use this one. But if you use this one, both parties have to agree to everything in this document, or it's not a valid termination. Okay. So it goes on to say that the intent is that we mutually agree on all the terms. Termination of the agreement is mutually agreed upon, and they agree upon how to do the earnest money. They designate a number 4 who gets the earnest money. Now it says, little side tip, pro tip here. The parties agree that the deposit shall be dispersed by the escrow agent, the attorney, in the following manner. Buyer agrees to release earnest money in this amount to the seller. That's a perfectly answered termination. Some people write by check, and it doesn't say who it's supposed to go to. And we're not really asking like what delivery method we want you want us to send the earnest money back to. We need to know who it's going to, who's releasing it to who. That's what that paragraph's for. Keeps going on to mutual. And then, this termination all effect. And one little thing, guys, if both parties weren't meant to sign it, it wouldn't have signature lines for both parties. I'm just bringing out if you don't believe my logic, I think your own logic can get you there. So the reason I'm bringing this up, guys, we've had a couple of contracts come up recently where the listing agent has gone, having received a mutual termination signed by the buyer, mutual termination of contract after due diligence, but the buyer wanted to get back earnest money. There was some sort of dispute over something. You didn't tell us the truth on this, whatever. Seller didn't sign the mutual termination because they didn't like how they wanted to deal with the earnest money. Seller immediately went and marked the listing active. That listing is still under contract. They haven't agreed to terminate yet because they're still negotiating the terms of that termination. The buyer might say, and let me explain that further. The buyer might say, I'll terminate, but I want the earnest money back. And if you won't give the earnest money back, fine, I'll buy it. And you have to let them, because they're under contract to buy it, and you haven't agreed on the mutual terms of the termination. That's it, okay? So if you get a buyer mutual termination document, and it says, but I want the earnest money back, and you as a seller don't agree to give them the earnest money back, you can't say, well, the buyer's terminating, I'm going to go mark the listing active again, because it's not terminated. You haven't agreed on terms. And the buyer might say, again, if you're not going to give me the earnest money back, then I'm still going to buy it. And you would have to let them. So if you go mark the listing active again and get a new buyer, guess what? They're under contract subject to this buyer's contract. And if they say, never mind, then I'll buy it, you're going to have a tough decision, a tough conversation to have with your seller in that instance. Okay, we've seen this happen twice in the past month where a buyer sent this over, wanted the earnest money back, and the listing agent went and marked the listing active without having a seller signed mutual termination document. And guys, I'm just here to tell you that's wrong. And when we tried to discuss that, it didn't, people got defensive. The form, I'm pulling this from a file, David. The form I'm looking at with the termination of contract by mutual agreement with release of earnest money. Now, there's one without release of earnest money too. This form is 390T. There's a mutual termination of contract form that I've also seen that's without release of earnest money. So if you guys are in dispute on the earnest money, but you want to go ahead and terminate contract, you can do that. There's another form for that. You do have to both sign it though. So same kind of concept. Anytime it's mutual, that means it's mutual, both sides. So there is a way to terminate contract while we figure out what we're going to do with the earnest money. And there's another form for that. I don't know the number of it. Someone comment if you know the number of the one that says without release of earnest money. But that's the one that is mutual with. And again, if you're after due diligence, you have to have this because otherwise that unilateral one it could be considered invalid. It's after due diligence. The buyer doesn't have a right to send that in. 350T is the unilateral termination form that doesn't have the mutual in the language. Yeah, and it may be, is that the unilateral? Oh, that's the unilateral. Yeah, exactly. So 350T is the unilateral one. And that's meant to be used during due diligence period. If there's a breach by the seller, I believe that's an itemized piece on there as well. I didn't pull up that one, guys, because my main point here is if it's not a unilateral situation spelled out on that 350T form, then you need to be using the mutual one. And if you're using the mutual one, then you have to have both sides sign it. And if you don't have both sides sign it, it's not terminated. So you can't go mark the listing active again, okay? It's very important to keep that in mind because, again, as soon as you do, the buyer's going to say, well, then if we can't agree on that, I'll just go ahead and buy it. You're going to have a new buyer signed, and you're going to have to explain to that seller who's your client and the buyer who, has put an offer in and thinks it's accepted, why it's not valid. Okay, so look, is it going to happen a lot? Hopefully not, but hopefully you guys are listening to me and using the right forms, but hopefully that problem's not going to happen. But you don't want it to happen to you, and you're only setting yourself up for a needless risk by rushing that listing active again without, I'm reconnected. Sometimes people send the incorrect form. Absolutely. Don't rush through a termination, guys, because it can bite you if you're not careful on that. If you guys have questions, if you get a termination, you're not sure if it's the right one to use, don't have your client sign it. Goodness gracious. You don't want to say, hey, client, here you go. This is what we want, and have them sign it. Run it by us. Look, if it's terminating, we're not in a huge hurry on it, right? But we're going to be able to get you an answer within an hour or two tops. So run it by us. Send it over. You guys have my cell. Text me. I'll take a look at it. You can just text it to me. I can take a look at it and tell you right away if it's the right one or not. But it has to be mutually signed. And that is something that most people that answered, and again, I'm trying to share wisdom, guys, because I saw that happen. And I'm like, ooh, that is not right. In fact, it bothered the buyer. One of the buyer's agents on one of the deals was a little bothered that it got, I'm not going to say relisted. It was changed to active again on the MLS because they haven't received a signed termination back from the seller. The due diligence money was certainly still in dispute, but it also wasn't technically terminated at all. There's an active contract. So you want to be really careful with that. Hey, Carly, thanks for watching. Hey, Jose. Thanks, David, for the comments. That's really helpful. Hey, Keith. Hey, Natalie. Thanks for watching. So I hope this is helpful. Take it back to your BICs. We had a BIC involved on one of them. Take it back to your BICs. Just keep it in mind if it's after due diligence that you have to have that mutual termination in most cases, and it needs to be signed by both sides. And if you're not sure if you have that in hand, please call your attorney, text me, let me know. Let me take a glance at it. I promise I'll do it quickly, and we'll make sure you're protecting your clients, protecting the earnest money the way it should be, but also that you're not marking a property active when it is by definition under contract, which means, gosh, guys, I'm just throwing this out there. People could see that as defrauding new buyers. The commission's not going to love it. I promise you, the commissioner, you remember, the real estate commission is who had these forms drafted for you. And you're expected to use them correctly or not use them at all. If you don't want to use them, you got to go through an attorney. But if you want to use them, you have to use them correctly. That's what the commission expects of you guys. So when they expect you to use them correctly, you got to use them correctly, which means if you have a mutually signed termination of contract and it's only signed by one party and you do something with that, that's on you and you shouldn't. So that's my 2 cents on the matter, guys. Love to hear your comments below. Again, I'm going to start tagging in some of these people from the other posts just so they see it, because a lot of these, these comments weren't really, I think that a lot of people do know this, but I want to make sure we all do and we don't step on any landmines there. But certainly something has to happen. You can't just mark it active. That's number one. You have to have something signed to go mark that active, or a court order, honestly. Or if you don't have that, at least have an attorney telling you to do it, so that when the commission asks you why you did, you can point a hard finger at an attorney. Don't do it on your own. It's just too much liability. Thanks, Teresa. Appreciate it. All right, guys, I think that's all I have for you on this live. I'm going to be doing one tomorrow on VA loans and how they can get you more commissions in 2023. I've not seen anyone talk about this. This idea popped in my head last night at a marketing event while talking to another lender. It is going to be maybe for some of you, a big idea if you know the right people and have the right clients. So, hey, Ted, thanks for watching. See you tomorrow, guys. Have a great Friday night.